Good morning, everyone. Today's presentation will cover three landmark legal cases concerning psychology and the death penalty. As you can all imagine, being put to death is a serious thing. If our lives are in jeopardy, there exists a limited number of people we can call to save our lives. If you are to be executed by the state after being given the death penalty, after your appeals are exhausted, there is nobody you can call, which is why it is essential that every individual is to be afforded the same protections and that these very protections be strong and airtight. The first of the three cases we will go over is Estelle v. Smith. Estelle v. Smith was argued on October 8th of 1980 and decided on May 18th of 1981 in the Supreme Court of the United States. Before making it to the Supreme Court, Estelle v. Smith traveled through four lower courts. These courts are the 195th Judicial District Court of Dallas County, Texas, the Texas Court of Criminal Appeals, the United States District Court for the Northern District of Texas, and the United States Court of Appeals for the Fifth Circuit. Estelle v. Smith was a criminal case in which they were seeking the death penalty. Ernest Smith was indicted for murder after taking part in an armed robbery of a grocery store, during which his accomplice fatally shot the clerk. The state announced its intention to seek the death penalty due to the seriousness of this crime. With that, a psychiatric examination was ordered to determine his competency to stand trial. The doctor who performed the evaluation was Dr. James P. Grigson, while the defendant was in jail. After his competency was declared, the defendant was tried and convicted. In accordance with Texas state law, at the penalty phase of the trial, a jury had to assess the future dangerousness of the defendant, one of the three questions in which the burden of proof falls on the state. At the defendant's sentencing hearing, the state had one witness. The witness was the psychiatrist, Dr. James P. Grigson, who assessed the defendant. The defense filed a motion to suppress the testimony the psychiatrist provided because his name was not on the state's list of witnesses. The legal issue to be decided here is, was the defendant's Fifth Amendment right violated by the evaluation when he was not warned of the risks associated with the evaluation, and was the defendant's Sixth Amendment right violated by the surprise introduction of the doctor's testimony during the penalty phase? When discussing the contentions of both parties in the case, the state argued that the use of psychiatric testimony in the punishment phase of a capital murder trial is proper and is necessary to allow the jury to have all relevant information concerning the character of a defendant, especially when the jury is making this important determination as to life or death. The testimony is only used after guilt is established and is not used for the purpose of incriminating the defendant. The defense argued that the use of such testimony and failure to warn on the behalf of the psychiatrist in the process of obtaining such testimony was a violation of their client's Fifth and Sixth Amendment rights. When discussing the decision of the court and the reasoning behind their decision, the court concluded that the doctor's testimony during the penalty phase violated the respondent's Fifth Amendment protection against self-incrimination because he was not advised before the psychiatric examination that he had a right to remain silent and any statement that he made could be used against him. In other words, the defendant did not know that there was no confidentiality between him and the psychiatrist. The defendant must be aware that an individual may not be compelled to respond to a psychiatrist if statements may be used against him during a sentencing proceeding. The surprise testimony introduced by the prosecution also violated the Sixth Amendment right to a fair trial. The resulting implications from Estelle v. Smith are 1. That the individual being examined must be warned about the purpose of the evaluation as well as the risks associated. A valid waiver of Miranda cannot be acquired unless the defendant is informed. 2. The defense must be aware of all witnesses at the discovery phase, not allowing for any surprise justice. Last, the state cannot force someone to complete a psychiatric evaluation solely for the purposes of sentencing. The next case we will go over is Barefoot v. Estelle. Barefoot v. Estelle was first argued on April 26 of 1983 and decided on July 6 of 1983 in the United States Supreme Court. Before making it to the United States Supreme Court, Barefoot v. Estelle worked its way through three lower courts. These courts are the Bell County District Court, the Texas Court of Criminal Appeals, and the United States Court of Appeals for the Fifth Circuit. The type of case is a criminal case in which the defendant was facing a capital murder charge. The facts of the case are as follows. Thomas Barefoot is convicted in a Texas court of the murder of a police officer. He is subsequently sentenced to death. The sentence was based off of an assessment of future dangerousness as defined by Texas law at the time. The prosecution's case against Barefoot rested upon two psychiatrists who testified against Barefoot based on theoretical assessments rather than in-person examinations. Barefoot's representation then appealed the ruling in Texas Court of Criminal Appeals. Texas Court of Criminal Appeals denied several appeals for both habeas corpus and certiorari and upheld the sentence. The United States Supreme Court then granted certiorari. The Supreme Court upholds the Court of Appeals' denial of stay of execution as well as the court's ruling based upon the merits of the case. Despite objection from bodies such as the APA, the Supreme Court ruled that the clinical testimony was admissible and that it was up to the adversarial system to determine the accuracy and weight of such testimony. Courts still commonly accept hypothetical clinical testimony in criminal cases despite many objections from psychiatric associations and lack of empirical evidence concerning accuracy. When discussing the contentions of both parties, the contention of the petitioner is as follows. The use of psychiatrists to testify as to future conduct is unconstitutional because psychiatric testimony cannot accurately predict future dangerousness and is likely to produce erroneous convictions. It is also unconstitutional regarding this specific case because neither psychiatrist had personally examined the defendant. Next, the contention of the prosecution. The prosecution argued that clinical testimony was applied soundly with regard to completing an assessment of future dangerousness according to Texas state law. The court ruled in a 6-3 majority against the defendant. The court stated there is no merit to the petitioner's argument that psychiatrists, individually and as a group, are incompetent to predict with an acceptable degree of reliability that a particular criminal will commit other crimes in the future and so represent a danger to the community. To accept such an argument would call into question predictions of future behavior that are constantly made in other contexts. Moreover, under the generally applicable rules of evidence covering the admission and weight of unprivileged evidence, psychiatric testimony predicting dangerousness may be countered not only as erroneous in a particular case, but also as generally so unreliable that it should be ignored as a whole. Nor, despite the view of the American Psychiatric Association supporting the petitioner's view, is there any convincing evidence that such testimony is almost entirely unreliable and that the fact finder and the adversary system will not be competent to uncover, recognize, and take due account of its shortcomings. Expert testimony, whether in the form of an opinion based on hypothetical questions or otherwise, is commonly admitted as evidence where it might be helpful to the fact finder in doing their job. The future implications of Barefoot v. Estelle is that clinical testimony, even that which is hypothetical, is admissible in court and is to be reviewed for merit by the adversarial system. The third and final case which we will go over is Atkins v. Virginia. Atkins v. Virginia was decided in 2002 by the United States Supreme Court. Before making its way to the United States Supreme Court, Atkins v. Virginia made its way to two lower courts. These two courts are the York County Circuit Court and the Virginia Supreme Court. This was a criminal case in which the defendant, Darrell Renard Atkins, was facing the death penalty. The facts of the case are as follows. Darrell Renard Atkins was convicted of abduction, armed robbery, and capital murder. In the penalty phase, the defense relied on one witness who was a forensic psychologist. The psychologist testified that Atkins, the defendant, was mildly mentally disabled. The jury sentenced Atkins to death, but the Virginia Supreme Court ordered a second sentencing hearing because of an error the trial court had made. During the resentencing, the same forensic psychologist testified. The state argued against Atkins' intelligence being lower than normal, and the jury again sentenced Atkins to death. The Virginia Supreme Court rejected Atkins' contention that he could not be sentenced to death because he is mentally disabled or deficient. The legal issue to be decided is, should mentally handicapped individuals be executed? Is the execution of a mentally disabled person cruel and unusual punishment which is prohibited by the Eighth Amendment of our Constitution? The contentions of both parties are as follows. The defense of Atkins argued that he is mentally disabled, so he should not be given the death penalty. Atkins was mildly mentally disabled, and this conclusion was reached based on his academic record and also his score on an IQ test, which was abysmally low at 59. The prosecution argued that he is intelligent enough and competent enough to be put to death. It was argued that Atkins was at average intelligence at least, and he was also diagnosed with antisocial personality disorder. The United States Supreme Court ultimately decided that it is indeed unconstitutional to execute an individual who is mentally disabled. This execution would have gone against the Eighth Amendment of the United States, which prohibits cruel and unusual punishment. First and foremost, a major implication of Atkins v. Virginia is that individuals who are mentally disabled cannot be executed, as this would violate the Eighth Amendment of the Constitution. Also, courts now rely heavily on mental health professionals when making a determination of whether a capital offender is mentally disabled or not. In conclusion, I would like to briefly go over the implications that these three landmark legal cases have on psychology, legal practice, and law enforcement following their verdicts. First, in Estelle v. Smith, the individual being examined must be warned about the purpose of the evaluation as well as the risks. The defendant must know that they do not have any confidentiality with you. A valid waiver of Miranda cannot be acquired unless the defendant is informed. The defense also must be aware of all witnesses at the discovery phase, which is the initial phase where both sides exchange evidence. This allows for no surprise justice, and this would surely violate a Sixth Amendment right to a fair trial if you just randomly introduce a witness. The state also cannot force someone to complete a psychiatric evaluation solely for the purposes of sentencing. Second, in Barefoot v. Estelle, the future implications are that clinical testimony, even that which is hypothetical, is admissible in court and is to be reviewed for merit by the adversarial system. Last, in Atkins v. Virginia, courts now rely heavily on mental health professionals when making a determination of whether a capital offender is mentally disabled, and you cannot execute somebody if it is found that they are indeed mentally disabled.